to go through the 7 opinions. We propose that we will read continuously, but in the event that someone will need a health break, either the bench or the bar, one will be at liberty to silently take the health break and just start.
Milady, before you start,
Yes.
may I request you for the completeness of the record, who they represent, so that the record may be accurate.
It's okay, we can have parties.
Good morning, my lady, the Chief Justice, my ladies and my lords, Senior Counsel George Oraro, Kamau Karo,
My lady and members of the court, for IEBC, Gedhu Moigai, Senior Counsel, assisted by Eric Gumbo, Justice Munyidia, Mos Wamboi Moigai,
my ladies, my lords, for the 18th and 21st respondents, my name is James Orengo, appearing together with my learned friend, Professor Ben Sihenga.
Please, my lady and members of the court, my name is Wawe, together with my learned friend, Mr. Kiragu, Mr. Paul Wanga, and Doctrine Chemneno. Thank you.
The Honorable Chief Justice, my ladies, together with Mr. Oraro Omoke himself, the third appellant, and remotely, Mr. Topua Lesinko and Margaret Kamau. Thank you.
Good morning, the President of the Supreme Court and Honorable Judges. My name is...
May it please you, my lady, the Chief Justice and the judges of the Supreme Court. My name is Nelson Andai Harvey. I appear together with Ms. Esther Angawa for the first to the fifth respondents. That is Dr. David Ndii, Jerotich Sei, James Gondi, Wanjiru Gikonyo, and Ikal Angelei.
With
My Lady, the Chief Justice and the Justices of the Supreme Court. My name is Caroline Gerono. I appear alongside Mr. Mutuma and Professor Kindiki for the 7th, the 8th, and the 9th.
If it may please the court, in the matter, my name is Kuyoni. I appear together with Mr. Mbarak Awath Ahmed for the Speaker of the National Assembly, the 13th respondent, and the National Assembly, the 15th respondent.
Commission. I'm Valentine Haminwa, appearing alongside my learned senior Dr. Haminwa and Velin Shigoli. Thank you.
Good morning, my Lady Chief Justice, Honorable Judges of the Supreme Court. My name is Job and 16th respondent, the Speaker of the Senate and the Senate.
May it please you, my ladies, my lords, the President of the Supreme Court. My name is Ndegwa Njiru. I appear for the 78 respondents, the County Assembly of Kirinyaga.
Good morning, Your Ladyship, the Chief Justice, Mr. Elisha Ngoya. We are on record for the 11th and the 12th respondents. Thank you.
Your Lordships, Your Ladyships, President of the Court, my name is Modani Nyuguto. I do appear with Senior Counsel Mother Karua for the 74th, 75th, and 76th respondents.
My lady, my name is Ochiel Miss Shitagwa Mwavishi. Most of like.
Good morning. The Chief Justice of the Republic of.
Thank you. I believe that is all about the appearances. I will also like to say after we finish reading, we will also issue a media summary of the judgment. August 2010, in what may be fittingly depicted as a symbol of national rebirth and renewal, Kenya promulgated a new constitution, which has been described world over as progressive. This moment marked a historic transition from the old order to a new one. The 2010 Constitution, its spells and other reforms meant to sustain human rights, equality, freedom, democracy, social justice, and the rule of law for the present and the future generations. The history behind making of the Constitution Amendment acts back to the process and sacrifices that were made by the Kenyan people over many decades during the search for a new constitutional order. Indeed, the preamble thereto reminds us of honoring those who heroically struggled to bring freedom and justice to our land. That has engaged all the superior courts on the question of interpretation and application with regard to not only the provisions of Chapter 16 that provides for amendment of the Constitution, but the entire body thereto, as the canons of interpretation shall be construed according to the doctrine of interpretation, that the law is always speaking. End of quote. This means that the Constitution is always speaking to the present and the future generations. Therefore, in changing, they are promoting the dreams and aspirations of the Kenyan people in a manner that is consistent with the Constitution. In addition, it is envisaged that the approach to interpretation adopted by a court should not render any article. It is not lost to this court that we are being called upon to provide an impartial and authoritative determination which will guide and act as an interpretive compass to the courts below, to the state agencies, and to all the persons. Before delving into the mandate under Article 163(4)(a) of the Constitution, as invoked by the appellants, it is instructive that we should place these appeals in the context by setting out very briefly the background. It is no secret that there have been a total of 3 attempts to amend the Constitution by way of popular initiative under Article 257 of the Constitution. These attempts were Constitution of Kenya Amendment 2010, Amendment Bill 2015, dubbed the Okwa Kenya Initiative. The requirements bill was subject to the court process, culminating in the instant appeals. Besides the above 3 attempts under the popular initiative, there have been more than a dozen other unsuccessful attempts since 2011 through parliamentary initiative route under Article 256. The instant appeals concern the amendment bill, whose genesis can be traced to the outcome of the 2017 presidential elections. Following the initial and repeat President Honorable Raila Odinga, the then leader of the opposition coalition, and himself on 9th March 2018. In line with their mutual commitment to create and foster a united Kenya, the President highlighting 9 problem areas which they deemed as negatively impacting on the peace and unity in the nation. Subsequently, the President established the Building Bridges to Unity Advisory Bind the areas and make policy, administrative, and reform proposals that would build lasting unity based on consultation with the citizens. Towards that end, on 26 November 2019, Building Bridges to a United Kenya, from a nation of blood ties to a nation of ideals. That report was presented to the President and the Honorable Raila Odinga, which was unveiled to the public. The President appointed the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report. Via a Gazette notice dated 3rd January 2020. The main objectives of the BBI steering committee or constitutional changes it thought necessary for the implementation of the recommendations contained therein. On completing its mandate, the BBI Steering Committee brings to a United Kenya Task Force report. This was done on 21st October 2020. And next to the report were a number of documents, including a draft Constitution of Kenya Amendment Bill 2020, Constitution of Kenya Amendment Bill 2020 was reviewed, culminating in the Amendment Bill, which was published by the government printer about a month later on 25th November 2020. Thereafter, the BBI, in support of the Amendment Bill, upon correction of the requisite number of signatures, the BBI National Secretariat submitted the same, together with the Amendment Bill, to the Independent Electoral and Boundaries Commission for verification and thereafter litigation. While the amendment process was ongoing, 8 petitions were filed before the High Court, challenging the constitutionality of the process, which resulted in the Amendment Bill and the contents thereof. 7 petitions were consolidated. Professors Duncan Ojuang, Osogo Amandi, Dr. Rita Musumba, Jackie Mwimari were joined as amici curiae, while Kituo cha Sheria and Filista Wakesho were also joined as interested parties. Most of the petitions contained in petition number E282 of 2020, David D. and others versus the Attorney General. We have also summarized the petition by the Kenya National Union of Nurses, the petition by the Third Alliance, in opposition to those petitions that were filed. The competency of the petition was challenged by the Attorney General, who argued that the issues raised therein were res judicata or subordination, which they duly did, and came up with a judgment which was appealed before the Court of Appeal. Before the Court of Appeal, the court had, by finding there was no quorum to undertake the constitutional and statutory mandates. It is also challenged the decision that the court misapprehended the provisions of Article before the verification exercise. In the High Court, this appeal was challenged. The Court of Appeal had the appeal and also the cross appeal by the Kenya Union of Nurses. In determining those appeals, the court framed 21 issues which were determined by the conclusions and findings that were pronounced in the read judgment by Musinga J. Those findings are there. I need not read them. And the third appellant were dissatisfied, and therefore they found these appeals, which were consolidated before us, and we were able to frame 7 issues for our determinations, submissions in our own judgment. I do not wish to read what each party said in the argument to support the appeal. The appeals were also opposed by the judgment. There were parties also who supported the Attorney General and the IEBC's appeal. That is the 13th and the 15th respondents. We have captured what they said. The National Secretary, the President, and we have captured what was submitted before us by Council in our long judgment. The 19th respondent, Isaac Arwoche, appeared in person. We have also captured what was said in the submissions. We have highlighted the specific parties who opposed the appeals. The first, second, third, fourth, and fifth respondents represented by Mr. Nelson Harvey and Ms. Esther Angawa have captured in our own judgment. The 7th, 8th, and 9th respondents are represented by Mr. Also relied on their joint submissions and made oral highlights, which we have captured in great detail in this judgment. The 11th and 12th respondents, represented by learned counsel, made submissions in opposition to the appeal. So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IEBC and also the quorum minimum. Also made extensive submissions, and we also have considered the briefs by the Hamisi, Professor Rosalind Dixon, and Professor David E. Randau, the first and second Hamisi. We have also considered Gautam Bhatia, the fourth amicus, also submitted a Hamisi brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth Amisi, and Professor Yaniv Rosnai, the sixth amicus curiae, Professor Charles Manga Forband, Professor Dr. Adem Abebe, Dr. Jack Mwimari, the Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those sub 4A of the Constitution, which clothes this court with jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and breadth of the pleadings and arguments is that they are focused on the interpretation and application of Chapter 16 of the Constitution and how that is to be done, the two superior courts below have traversed and touched all the key provisions of the Constitution, and having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially on the basic structure. It is pertinent in the circumstances to point out that the basic structure doctrine, as added in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment further would follow a 4-sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and the referendums of the Constitution and beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensive. I mentioned some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Savananda case, a decision of the Supreme Court of India, and the 2 Land Reform Acts to allow state government to acquire privately owned land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges, with the 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by part of the Constitution. The doctrine places substantive limits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Constitution I have recited or restated the provisions of Article 368 of the Indian Constitution, From that provision, it is clear from its reading that the amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this preposition, I have also read the books by and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its various Africas have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic into a universal norm of constitutionalism. And for that, I have referred to the writings by Richard Albert, Maukas Makize, and Therese O'Keefe. Given that the basic structure doctrine has not matured before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause, compensation commissions and other. This court developed the interpretive model to be followed. In that case, and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio-economic and political to take into account our constitutional history, especially bearing in mind that the doctrine, which found roots in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments of the Constitution, requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed from the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend, the starting point should be the rationale behind the provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an understatement to say that Kenyan independent constitution was flexible, giving the legislative wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the Constitution that it lost its original character. The most significant amendments being the merger of the Senate and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, they amended the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the Constitution traced by wanted, and I quote, "There is a need to protect the Constitution against indiscriminate amendments." What emerges from the historical account is that amendment power that are able to protect the Constitution order from abusive amendments. But this was not all. There was also a recognition that the Constitution must remain flexible in order to adjust to political, social, economic ways in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway under Article 2 of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the party to a referendum, these are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10(2), the Bill of Rights, the term of office of the President, the independence of the judiciary, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum and Article 255(2) must satisfy two conditions: at least 25% of the registered voters in each over majority of the citizens. A reading of the three pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of IPA Amendment in the pre-2010 era and sought to place the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepen public participation, as well as imposing a downstream constrained veto by stipulating that they amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the 16, reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutions of the Constitution. The core foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and of the Constitution. In my view, therefore, the framers of the Constitution were aware of the basic structure doctrine, chose to ring-fence some key features from flexible amendments, and if it was their intention to provide for eternity crosses or the basic structure doctrine, nothing, and thereby devise a four-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16, demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis of all the 21 unsuccessful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to point out Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans did not want another extreme where no amendment can take place. That is from hyper amendment to outright rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility in the process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment through an enhanced, inclusive, and participatory process that is in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with, for example, eternity crosses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper-amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution, provided to demonstrate the lacuna in the Constitution and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 history of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions of our Constitution. We have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with the judiciary creates people-centered, our nascent democracy that respects the doctrine of separation of powers by vesting legislative power in the legislature to create a fourth pathway within the scheme of amendments would bring into account where we are at in our constitutional democracy. Kenyans needed to be consulted on whether it is their wish to introduce the fourth pathway for amending the Constitution. In other words, we judges should be sovereign power vested in the people by introducing a constitutional amendment through judicial fiat. Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abuse of amendments power, like the basic structure and doctrine. This is in line with the view expressed by Professor Rosaline Dixon and David Randau. My take home from this scholarly perspective is that tiered design of constitution. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration, more difficult, the amendment process, the rest there is need for a doctrine of implied limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involve multiple institutions, is time-consuming participation by the people in deliberations over the merits of the proposed amendments, and as downstream veto by the people in the form of referendum, there is no need for judicially created implied limitations to amendments power through importation or exhausting homegrown mechanisms. Moreover, I fully agree with the portion of the judgment by Sishare J, where she questioned the viability of relying on judges to interpret on case-by-case basis on whether a particular provision. To put this into perspective with respect to our constitutional architecture, amendment of entrenched provisions of the Constitution relating to the matters listed in Article 255(1) through popular initiative route requires, first, the Article 10(2) of the Constitution. Second, correction of 1 million signatures from registered voters in support of the initiative as provided in Article 257. Third, support of the initiative through approval as stipulated in Article 257. 7. Fourth, consideration of the bill by the bicameral House of Parliament, Article 257(10). Fifth, subjection of the bill to a referendum in terms of Article 255, in which at least 20 counties vote in the referendum, and the amendment is supported by a simple majority of the citizens voting in the referendum. 6. It should also be appreciated that the processing of the bill in the county assemblies and the bicameral houses of parliament is in terms of 88(4)(g) imposes an obligation on voter education on IEBC. Amendment of the entrenched provisions under parliamentary initiative rules by dint of Article 10(2) of the Constitution requires public participation, which must inform the entire amendment process. Second, the amendment bill Looking at the two pathways for amending the entrenched provisions, it is inescapable to conclude that amending the core of fundamental provisions of the Constitution is a multi-staged, multi-institutional, time-consuming process of the fundamental aspects of the Constitution, is transparent, inclusive, engenders the participation of the people, in a democratic governance. I then the set criteria as to when judiciary created basic structure doctrine is inappropriate and undesirable. Therefore, the two courts below and by finding a fourth judiciary created pathway for amending the Constitution, which is with respect tantamount to amending the Constitution of the court. To buttress the point of tiered amendments post-2010 Constitution, the amendment practice post-2010 Kenya illustrates is an adequate work against abusive amendments. As pointed out by Sishare J in a dissenting opinion at the Court of Appeal, there have been 21 failed attempts to amend the 2010 Constitution during the first decade of its operation route. It is also notable that although the amendment bill had gone the farthest in amendment process, it was yet to be subjected to the ultimate downstream veto of the referendum process. Comparatively, of major amendments by its 10th birthday. In essence, it is right to conclude that the resilience of the 2010 Constitution in its first decade disproves that Kenyans attained the goal of balancing flexibility with Chapter 16 of the Constitution. It ought also to be appreciated that judicial protection of implied limitation to the amendment powers, such as through the basic structure doctrine, become increasingly require a civil constitution that can be amended fairly easily. Therefore, while it was inappropriate in the pre-2010 dispensation for the High Court, Lingera J, as it then was in the Joya case, to recognize the basic structure doctrine need under the 2010 Constitution. This view is founded on the premise that the risk of abusive amendments has been tamed by the tiered amendment process that entrenches the core of essential provisions through a heightened, elaborate. Considering the progressive nature of the Constitution, a three-judge bench, Koriu, Goge, and Odunga in Priscilla Dururu case, expressed skepticism as to the continued relevance of the Constitution. In contrast, the unique context of India, with a too flexible constitution that grants the legislature the wide discretion in amending the Constitution, arguably justifies the judge-made basic structure as developed and practitioner order and prevent the practice of abusive constitutional amendment given the low threshold for amendment in the text of the Constitution, just as it was in our case prior to the 2010 Constitution. Although I disagree with the judgments of the majority structure, post-2010 constitutional order. I will briefly highlight some of the critical aspects which were not considered by the two superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number one, the superior courts failed to appreciate that the concern with the culture of IEBC Amendment had already been taken into account during the drafting of the Constitution, design of flexibility and rigidity. In such a context, the correct judicial posture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the former constitutional amendments. Therefore, there is not to go outside the four corners of the Constitution to create a fourth pathway for the amendment of the Constitution. Number two, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the three-tiered process in practice in the post-2010 dispensation in the analysis of the Kenya's constitutional history, which shows that Chapter 16 of the Constitution has brought stability in the constitutional system in contrast to the culture of IEBC Amendment under the former Constitution. There have been multiple attempts to amend the Constitution, which were all unsuccessful, as in the Indian case. Three, the Court of Appeal failed to take into account the fact that Chapter 16 is one of the entrenched parts of the Constitution and Article 255(1) of the Constitution. Therefore, it could not be amended by the court through created fourth pathway following the constitutionally ordained amendment process provided for under Article 255(1) of the Constitution. And fourth, the Court of Appeal failed to appreciate that Kenyans were aware of the idea around the basic structure doctrine during the Constitution making, and yet did not embrace the idea of a veto to the amendment power as represented in the basic structure doctrine, as well as related to doctrines like eternity clauses. The CKERC report on page 76 indicates that Kenyans yearned for power features of the Constitution through a referendum and an inclusive and participatory process. This was done through the provisions of Article 255 of the Constitution. Another aspect of the majority judgment of the court that I need to address relates to how the two courts treated. It is evident that the basic structure and doctrine within Kenya's constitutional system was largely turned on historical inquiry to clarify and provide interpretative guideline drafting of the past, celebrated the virtues and utility of the historical context. The background to the adoption of the Constitution in the Constitution interpretation is imperative. Courts should endeavor to extract and have a view of the complete account of the historical background to the constitutional provision being interpreted. Where a court embraces an account of history that marginalizes, excludes, or suppresses or omits some portions of history distorts, or rather fails to illuminate the meaning of the constitutional provision being interpreted, hence misleading the court to reach an erroneous conclusion. Before leaving this part, advanced by Dr. Kaminwa, that the basic structure and doctrine is applicable in Kenya pursuant to the provisions of Article 2(5) of the Constitution. The provision reads, and I quote, "The general rules of international law shall form part of the law of Kenya." In the case of Mitubel, where it was held, and I quote, "In light of the foregoing, we hold that the once general rules of international law in Article 2(5) of the Constitution refer to customary international norms, including jus cogens. There is a general 38(1)(b) of the Statute of International Court of Justice, a general practice accepted as law. That is both sufficiently widespread and consistent practice, and what states have accepted as law, opinio juris, accompanied of non-refoulement of refugees, and granting of immunity for visiting ends of states. Since the basic structure and doctrine is a constitutional law principle acceptable in just a number of states and not an international law principle, international law principle. Therefore, Article 2(5) of the Constitution cannot be the basis for founding the applicability of the basic structure doctrine. In the end, I find that the basics prescribed by the High Court and the majority of the Court of Appeal are not applicable in Kenya under the Constitution. Any amendment to the Constitution must be carried out in strict conformity with the normative standards and provisions of Chapter 16. The second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment, and popular initiative routes provided for, and like other norm-producing process, a constitution amendment process starts with an initial decision. That is the initiation or activation of the process. The initiative speaks to how the amendment process starts. Elections in which the President was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the president through a majority decision delivered on 1st September 2017, and ordered fresh presidential election to be conducted within 60 days of the ratification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, with October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence and of tension. The President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that between the two political building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges and identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and National Unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by the introduction of the popular pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution making history that I have highlighted demonstrates that a popular initiative was a tool for constitutions. Amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of the fact on direct sovereign power to be expressed as contradistinguished with a parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from as in other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinct from the Constitution. Democracy can only be exercised by the people, not their representatives, since that will convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process or citizens, not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be markers. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative, right motive of the Constitution, which is concerned with tampering or limiting the powers of the president. Design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. Explicit of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the Constitutional Amendment Bill is presented for assent. The President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be in both a prayer and an umpire in the amendment process. The last reason for finding that a state initiative is to be found in Article 255, 3b of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It cannot for the text of the Constitution makes this distinction. This brings me to the inescapable conclusion that state institutions and state organs such as the presidency cannot initiate of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the President and even the Attorney General sustained an argument that barring the President from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the President's political rights as protected in Article 3. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that article that the citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizens or institutions, state organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the President, when acting in his private capacity as a which is a state organ, the Presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of Presidency and other state institutions from initiation of a process to amend the Constitution through the popular one of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed, who are the initiators and promoters of the impugned constitutional. For starters, the President and the National Executive took certain actions which portray its law in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off on the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my findings by the two superior courts that the President was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the President of the state institutions are not institutions. Whether the second schedule to the amendment bill was constitutional. To put this question in context, It ought to be appreciated that the second schedule was intended to serve as a transition, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with the words 360. 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule directly allocating and apportioning the proposed constituencies to specified counties were challenged. Violated the basic structure of the Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. To begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure and doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. Direct removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary, the centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4.2 and 10.2a of the Constitution. Further, since the constituencies are units of social national government, forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10, accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subject to case, that provided that there should, the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the relation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenya bill was made, including the addition of the second schedule. This leads therefore to my conclusion. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10(2) of the Constitution. I move now to the fourth issue on the president. Held that the President was not served with the petition number E400 of 2020 in the proceedings before the High Court in which this question arose. It was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, it should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the courts or tribunals' jurisdiction to hear a matter because the parties against whom further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official functions, the performance of their functions. For example, Article 160, a member of the Judiciary, Article 250, a member of the Commission, Article 143, criminal proceedings shall not be instituted against the President or a person performing the functions of that envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices, whereas the President enjoys immunity as both 143 to the effect that the President or the person performing the function. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143(2) to Article 259 for an holder of an independent. This leads me to the inescapable conclusion that the immunity of the president is unlike that of the other state actors. The president not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for the public. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts, I am conscious that part of the president's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the president either acts or fails to act in the belief that either that power exists, or then such proceedings would fall within the immunity contemplated in Article 143(2), in that it would be within the performance of the president's functions. There is no provision allowing or requiring the president to seek an advisory opinion for the judiciary before exercising their duties or before determining whether they have power to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution, with the provision that the president is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other means that there is a clear avenue to check the president's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect, under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, who by virtue of being the legal representative of the government in legal proceedings by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, the findings of the two superior courts and the ramification of rendering Article 143 to Constitution that resorts to an amendment by the judgment is tantamount to judicial overreach. This brings me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that of the office. I hold that civil proceedings cannot be instituted against a President or a person performing the functions of the President, of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President's public participation. The issue was framed by the court with two components. The first relates to the role of IEBC under Article 257(4), whether IEBC is under an obligation to ascertain that promoters of a popular initiative from the provision of Article 257(4) that imposes an obligation on IEBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IEBC was obligated to ensure that the promoters of the... It is necessary to keep in mind, to keep reminding ourselves that IEBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as the national value and the principle of governance. Whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the four corners of their constitutional order as undertaken public participation. The exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on complying with the requirements of public participation before determining that the amendment bill and met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed relates to whether there was public participation in respect to the amendment's foundational value and principle of governance and Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. That's requirement because the whole process may be rejected by IEBC like it did the two popular initiatives dubbed Okoa Kenya and Funguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I'm of the view that the requirement of public participation during the period proceeding and during the collection of signatures under the popular initiative requires participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, time of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input. Parliament is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IEBC, have an obligation to facilitate and broaden that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaning. And the question of burden of proof, Okwengu and Kiagi JJA earned the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of others. A slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows they are aware, co-chairperson of the BBI National Secretariat, in his affidavit sworn on February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. He deposed that BBI Task Force Steering Committee voluntary nationwide public participation. In addition, he annexed to his affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the Steering Committee report and the deposition by Dennis Waweru, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. And as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the Steering Committee report that took place on 21st October 2020, where in the draft amendment bill was attached and unveiled to the public. This version did not have the second time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation, it is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation acting with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. Raised in the High Court, bind petition number 416 of 2020, it was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257.4. As at the time the verification process was raised, the High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the court, infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution, while Article 88 of the Constitution establishes IEBC composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provides as follows, I quote, each commission shall consist of at least 3, but not more than 9 members. Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of Parliament to make a provision for the appointment, effective operation of the IEBC, appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act as to whether IEBC composed of 3 commissioners would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the I-1 of the Constitution, which expresses the supremacy of the Constitution demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament Constitution is supreme, and this has been emphasized by the decision of this court in the case of Hassan Joho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of three commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it under the verification process under Article 257 of the Constitution. Of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Kwengu, Kiagi, Musinga J.E. disagreed with the learned judges of the High Court and they held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On its part, to your J.E. held that since IEBC had not received the requisites, the first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a at the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was here to be subjected to the county assemblies for debate. This means that IEBC was here 25710 of the Constitution and not a reason to yacht JEA was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 27710 of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10 to and 89.7 functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public foundation. There was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake 57(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum of this litigation and also the other courts below. That is my judgment. I will now request the Honorable Justice Ouko to read his judgment.
Appeal consolidating 2 others marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 2 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, only way to a new beginning. And so at 10:26 a.m. on Friday, 27th August 2010, with a single stroke of his pen, Constitution before an ecstatic Kenyan people, and as cannons broke into a 21-gun salute, the President released 2 white doves. Having emerged from this phase, Kenya embarked on building constitutionalism, giving meaning to the terms and values of the supreme law to which Kenyans need. It was time for the people to read meaning into its words. It's only through this robust enforcement, application, and interpretation by courageous citizens, lawyers, legislature, executive, and even more so by judges. That and so, with the difficult history of constitutional making enumerated in the lead judgment of the Honorable the Chief Justice, the question I pose: have the Kenyan people stayed true to the people of Kenya, adopt, enact, and give this constitution to ourselves and to our future generations? So there were 7 issues that were framed, the first one being that on under has been synonymous with the basic structure doctrine. And although the term basic structure has not been used, has been used in a few cases in this country in the past, it is during the hearing of this vote that it became a household name. I suppose, knowing Kenyans in our true unique sense, there may be children today who are called basic structure. Perhaps basic structure George Ochola. Just as there may be also in India, to the iconic case as the petitioner. Unfortunately, I believe you are all aware, Mr. Kesavananda passed on the 6th September 2020 at the age of 79 years. The origin of basic structure doctrine has largely been, yet it is this German scholar who exported it to India. Professor Conrad's theory, which was applied in Kesavananda, postulates that there are implied limits on the power of Parliament to amend certain provisions. Under Article 368 of the Constitution of India, it is Parliament and Parliament alone that is reposed of the power to amend the Constitution. And indeed, clauses 4 and 5 even explain to amend the Constitution. No amendment of the Constitution made by Parliament pursuant to the provisions of the Constitution can be called in question in any court in India on any ground. However, in construing, notwithstanding, the Supreme Court in Kesavananda held that although the article donates exclusive power to Parliament to amend any provision of the Constitution in accordance with the procedure in that article, the powers could not be used to damage, emasculate, destroy. Under Article 76 of the German's original constitution, called the Weimar Constitution, Parliament had the power to amend the Constitution with the procedural restraints that required 2/3 votes of the members of its Parliament to pass an amendment. This same procedure, a procedure which is anchored in the Constitution, effortlessly to overhaul the entire Weimar Constitution and arbitrarily took away rights to freedoms of speech, expression, association, and habeas corpus. In their new constitution, the Grand Gazette, the Basic Law, substance substantive limits have been introduced to the amending power of Parliament. Article 79 of the Basic Law explicitly bars democracy, rule of law, separation of powers. Our own history is equally replete with examples and instances that led to agitation for constitutional reforms, as the former constitution was in no better ranking than the Indian or the Weimar under Section 47, and vested wholly the power to amend it in Parliament, a common denominator with the Indian and the Weimar constitutions. Our Parliament under Section 47, like parliaments of the two nations, could indiscriminately change and did, in fact, to reverse the trend and save the Constitution, leading to the promulgation of the 2010 Constitution, is well known and are chronicled in detail in my main judgment. But why is this history important? Just like India and Germany and the decision of the courts in those jurisdictions in applying the doctrine. Constitutions the world over reflect the uniqueness and specificity of each society, even if lessons or experiences can be drawn from those places. In the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the situation the Supreme Court of India was addressing in Kesavananda is unique to India, based on the specific provisions of the Indian Constitution, Article 368, to be exact. Their experience and also based on their history generally. To address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approach to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Kesavananda in interpreting Section 4768 of the Indian Constitution, in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitutional making process, from the Boma's draft, the Wako draft, Constitution embodies the will and aspirations of the people. They must be central to its amendment. And that there ought to be a balance, to have a constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the or multi-stage design model codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendments and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assembly. Attempts to utilize both parliamentary and popular initiatives have failed essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill of 2016, Punguza Mizigo Bill of 2021 embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below and the dilemma flowing from them is the imprecise scope of Kenya, for instance, and not amendable through the procedure in Chapter 16. What does it mean, for instance, when the High Court and the Court of Appeal accept, on the one hand, that all articles in the Constitution are amended statement by declaring that basic structure of that very Constitution cannot be altered using the amendment power in the Constitution? What does it mean when they declare that the basic structure consists of the preamble, the 18 chapters structure? Where do Kenyans who wish to propose amendments to the Constitution go to be shown which provisions cannot be amended using Chapter 16 procedure? Do they go to some deity, some oracle of Delphi, for instance? The interpreting in India the parties have brought to them for resolution in the first place. Amending the Constitution is not a light matter, therefore limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavan and the case, it constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and collision of views, constituent assembly, debate, and ultimately the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill amounted to dismemberment of the Constitution. Besides the number of articles sought to be amended, the courts were concerned about the overall to, and I quote, shake the foundation and alter the identity and character of the Constitution as to effectively dismember it. The learned judges variously defined the word dismemberment to mean doing any of the following in the Constitution: completely change identity, abolish, tear apart, amputate, and rough mutilation. Do the proposals in the amendment draft bill create a new constitution? It employed by the learned judges to describe the proposals in the bill and to suggest that the proposals were a dismemberment of the Constitution. Are they so? In my most respectful, were an overkill, and the sledgehammer employed to deal with them was in itself disproportionate. I end this ground where I started. However great, however progressive a written constitution may be, history, experiences, and to determine the law under which they wish to live. And no generation should bind the course, aspirations, constitutional expectations, values, principles, and objects of generations to come. The language of chapter, inference or implication. Neither the explicit nor the implicit language of the Constitution, the history of constitutional making, or any principle of constitutional interpretation in this country permits the courts to do what the courts have accused previous parliaments' alien method of amending it. In the result, I would set aside the judgment of the Court of Appeal and hold that to the extent that the basic structure doctrine limits the amendment power contrary to the express terms of Chapter 16 of the Constitution, it does not apply to the Constitution other than the steps outlined in Chapter 16. The second issue is on the role of the President in the process. This question to me, and of course the question of basic structure doctrine, are the real norms of this discretionality of the process leading to the formulation of the draft bill based on the true construction of Article 257. The High Court was persuaded and declared that the President does not have authority under the Constitution to initiate changes to 56 or by a popular initiative under 257. The Court of Appeal, in a unanimous decision, agreed and affirmed that conclusion. Friday, 2018, which was the same day the Justices of the Court of Appeal elected me as their president at Safari Park Hotel, will be remembered as one of the many defining moments in the history of Kenya. It was on that day that, in a move that took me, with whom he had recently engaged in fiercest and bare-knuckle political contest, met and agreed in what has come to be known as the handshake to end their political rivalry that had been witnessed in the previous elections. The last political contest between the two was ease the seething tension and restore peace, unity, and tranquility in the country. To realize this objective and as an understanding of the handshake, the two agreed to pursue a 9-point agenda style. I trace these events to mark out the role of the President in the process. By a Gazette notice of 31st May 2018, the President appointed a 14-member team known as the Task Force on Building Bridges. Notice of 10th January 2020, the Steering Committee on the Implementation of Building Bridges to a United Kenya Task Force report was also established, and as the name suggests, to implement the report of the task force. The Steering Committee's report was presented to the President on 21st October 2020. It was subsequently launched on 26th October 2020 at Bomas of Kenya in an event presided over by the President. Building Bridges National Secretariat, whose I have not been able to trace on record any appointment letter or a Gazette notice, appears on the scene. So, co-chaired by Honorable Dennis Waweru, a former member of Parliament for Dagoretti South. On 25th November 2020, at the Kenyatta International Conference Center, the President launched the draft bill and rolled out the collection of signatures to support the initiative. A popular initiative for amendment to support it. It is the promoters who must formulate the draft bill. They are required thereafter to deliver the bill and supporting signatures to IEBC. And from this point, the process is self-executing along the lines in Chapter 16. The definition sources employed by both the High Court and the Court of Appeal are unanimous that the term popular initiative can only be an initiative by the general public. In common parlance, simply the people. The citizen. On the other hand, the word promoters in the Constitution is used only in Article 157. It is apparently a term of art in the context of amendment of the Constitution, describing the persons not in the company law sense or initiate or champion constitutional changes. Beside the definition of the term popular initiative, there is history behind the process for the intendment of the framers. The CKRC final report 2005 acknowledged and recommended that apart from Parliament from this report. With that history in mind, there cannot be any debate as to the target of Article 257. It is the people. The suggestion that Honorable Waweru and Honorable First, the Secretariat emerged, as I've said, from the blues, as it were, for the first time in the process. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, so an affidavit of 5th February 2021 to state roles that the task force and the Secretariat conducted a robust nationwide public engagement and collection of views, and that from these views it made various legislative, policy, and constitutional amendment proposals in various fields affecting origin, its ancestry, its family tree, its gene cannot be conceived. The affidavit says it all. The great-grandfather is the handshake, yes, initiative, alias BBI. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters, and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence in the organization to complete the forms and sign appropriately and urgently the forms. The conclusion I reach, as should be apparent on the first limb of this ground, is that the President, as a matter of co-chairpersons, when it was too late in the day and beyond recall, that the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances. Executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the problem from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda have not been violated. The President's role in the constitutional review process has been preserved and is by Parliament, and to request the IEBC to conduct conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from these, the President, as indeed any other voter, is entitled to support a popular initiative. I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, of the number of constituencies today, by dint of Article 89(1), stands at 290. The Superior Court below were unanimous, and I am in agreement with them that Article 89 is amendable in accordance with Chapter 6. The quarrel with the second schedule relates to paragraphs 1, 2, and 3 of the draft bill. After delimiting the constituencies for the National Assembly to 360 and an additional 70 constituencies, the schedule sets out the is donated to the IEBC. The period being at intervals of not less than 8 years and not more than 12 years, but on condition that any review must be completed at least 12 months before a general election of members of parliament. Furthermore, if a general, that I've said, by providing only for a single criterion, the population quota, as the basis for delimitation, it went ahead and distributed the newly created 70 constituencies to specific counties. It directed on the new constituencies on the single criterion. It ignored the irreducible constitutional consideration and the existing scientific criteria in Article 89. And finally, it ignored the principle of public participation. In view of the foregoing, consistent with the Constitution, to which extent it was correctly so declared, I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition for clause 26 to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee and whether the steering committee had locus standi to promote constitutional thought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. That the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering, having arrived at the conclusion that the President on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the President was properly sued in his personal capacity. All the orders made against him in that capacity ground that the President was not qualified our President to initiate it, confirming that his actions, the Gazette notices and so on, were official. Mr. Alochier's question was effectively answered, that no civil proceedings could be instituted sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Alochier's contention was respectfully slightly, has however presented a chance to this court to express itself directly on the question for the first time. And Article 131 of the Constitution, the people of Kenya acknowledge the immensity and enormity any other state or public office except that of the President. Again, because of the exerting nature of those responsibilities, the Constitution grants the President immunity to enable him or her to discharge the functions enumerated above with as much functions of the state and not personal. Any person who is aggrieved by the exercise of state power by the President has a recourse. First, to challenge the action in court by naming the Attorney General as a respondent in a judicial review application or a constitutional reference, or secondly, leaves office. And of course, there is the option of impeachment motion, which may be moved in Parliament against the President for engaging in gross violation of the Constitution or of the law, or committing a crime under national or international law, or for gross misconduct. 43 would set aside the judgment of the Court of Appeal to the extent explained. The fifth issue was the place of public participation. The twin questions before us are specific. The place of public participation and whether there was public participation generally in respect of the draft bill. Public participation today is a constitutional imperative recognized as one of the principles of good governance and accountability. 57.4 voters upon receipt of the draft bill and the 1 million signatures. I've already, in the previous paragraphs, found in agreement with the two courts in respect of the delimitation of constituencies that there was no, the role of IEBC does not extend beyond verification that the initiative is supported by at least 1 million registered voters without going behind the process to inquire if the promoters did conduct public participation. It is the duty of the promoters to carry out the Constitution. They must persuade 1 Kenyans to vote in support of their venture, to convince the assemblies and parliament about the prospects of the initiative, and ultimately Kenyans in a national referendum. It is the promoters, back to the Secretariat, according to the steering committee, both houses of parliament, some county assemblies, Odinga, there was public participation prior to and in the course of signature collection. Whether or not there was public participation is a matter upon him who affirms and not on the one who denies. The burden was upon those who allege that there was no public participation to prove that assertion. Not a single person was presented to support the statement and to rebut the evidence in support of public participation. In support of public participation of the Court of Appeal on the question of public participation. The sixth issue is on the composition and quorum of IEBC. And it is a common factor that IEBC was not fully constituted when the bill and the signatures were presented to it. The departure of Commissioner Akombe, who fled the country and announced her resignation while abroad on 18th October 2017, 16th April 2018, Commissioners Mwachanya, Dr. Kibiwot Kurgat, and Consolata Nkatha, the vacancies were not filled until September 2021, nearly 4 years from the date of those resignations, and 1 month after the decision of the Court of Appeal in this very matter. Article 250, commissions, it declares that each commission shall consist of at least 3 members, but not more than 9. Section 5 of the IEBC Act, the chairperson and 6 members. For the conduct and regulation of business and affairs of IEBC, Section 8 of the Act refers to the second schedule, which at paragraph 5 provides for a quorum of 5 members. Of the paragraph and the decision of Mwita J, I have also considered the effect of the decision in Isaiah Kibiwot Kangwon case, considered too the CKRC recording the debate on the Election Laws Amendment Bill 2017. I have taken into consideration international best practices and borne in mind that IEBC is a body corporate with perpetual succession. The IEBC and strategy, as well as providing oversight, the Secretariat and supporting units, directorates, divisions, and committees, being the professional and technical arm of the IEBC, perform the day-to-day administrative functions of the Commission. The Court of Appeal and the High Court to say in the same breath that the IBC was properly constituted with 3 commissioners but lacked quorum to transact business and conduct its affairs. I arrive at the conclusion that with 3 commissioners, the IBC was properly constituted by the Court of Appeal that the IBC lacked the necessary quorum to conduct any of its business under Article 257 of the Constitution. The final framed question is on the referendum question. Whether Article 257 termed by Mr. Murara. Again, the details of my analysis of this issue is contained in my judgment, where I have explained in conclusion why I think the issue was premature. Noting that the draft bill had not been returned to a referendum to advance it, the nature of a question or questions to be framed by the IBC was not ripe. In the end, the Court of Appeal erred in failing to set aside the determination of the High Court on this issue for violating the doctrine of Right 10 of the Constitution requires the specific proposed amendments of the Constitution to be framed as question or questions. The details of what I've just rendered is in my main judgment. I thank you, Judge President.
Thank you. To read.
Colleagues and counsel, my judgment is 149 pages. I will greatly summarize it for purposes of this delivery. And there's a presumption that all counsel can read. So please do read it. Because 2, I have read the judgment of the Chief Justice and President of this court, and I will adapt it for purpose of my judgment. I also agree with the reasoning and findings, save where I shall express myself to the contrary. In that context, when the Kenyan people gave themselves the Constitution 2010, it was a matter of over the years. For example, initiated the Punguza Mizigo, Lighten the Burden initiative at a referendum on a number of issues. That initiative failed. I have therefore taken into account the pleadings, the submissions, and my opinion on each issue and history of the basic structure. I looked at Kesavananda at length and the history of Kesavananda and the findings in Kesavananda. I also delved in the history of Article 257 on amendments through a popular initiative. Reports. I reproduced sections at page 75 where the Commission said this. A distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions, security, finance, and the system of government. The final report then came up with the following recommendations. I'll only pick on 2. Recommendation number A, the new Constitution should have some entrenched provisions. For example, human rights, that Parliament does not have power to on amending the Constitution itself. The provisions establishing the Republic of Kenya, the provisions of sovereignty of the people, the provisions on supremacy of the Constitution, the Bill of Rights, the separation of powers, provisions in existence and powers of independent commissions and bodies. Those are what morphed into Chapter 16 of the 20th Constitution, and by those provisions, the people attain the right balance between constitutional flexibility and rigidity, and provided sufficient and strong safeguards against the culture of hyper-amendability. And Chapter 19 of the WACO draft also identical as to what's contained in Chapter 16 of the Constitution. Today, history has shown us that the people did not intend to immunize the 2010 Constitution. To the contrary, they envisioned that they could amend the provisions of that Constitution through exercise of self. If the people wanted to entrench provisions of one or to immunize any of the provisions of the Constitution, they would have done so expressly. It is therefore correct to say that courts should not, by judicial craft or innovation, impose hurdles to prevent the people from amending the Constitution, provided that procedural requirements under Chapter 16. I made reference to my own decision in Commission for the Implementation of the Constitution versus the National Assembly of Kenya and two others. I had counsel in this court say that that was the introduction of the basic structure doctrine by courts in Kenya. That is not anything near the truth. That judgment was addressing amendments by Parliament to Article 260 of the Constitution, Malaysia, to Singapore, to Israel. And I have said in my judgment that each country has taken a different approach on the basic structure doctrine because each country has its unique circumstances, and we must do the same. I've also looked at the Njoya case, and I've explained why the Njoya case, the circumstance it was made, the context in which it was made, and the reason why the Njoya case cannot be relevant in processes under Article 257. And going to the four sequential steps relevant and useful, not in amendment under Chapter 16, but amendments, but making of the Constitution, should we as a country ever decide again to do away with the present constitutional order and create a new one. And therefore, in summary, on issue number one, My findings are the manner suggested by the first, the fifth respondents, and that the four sequential steps set out by the High Court and the majority of the Court of Appeal only apply when a new constitution is being made and not in any amendment process under Article 257. In addition, based on our history, the text of our Constitution, such as the CKRC Act and 1997, that the four sequential steps should be anchored when and if the people ever want to change the present constitutional order. Those are my findings on issue number 1. On issue number 2, I have read the Chief Justice's of CKRC reports, Article the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like to your JA, I'm certain that popular initiative is people-centric. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 2 in 90 days a national referendum for approval of the bill and then retire to assent to it as a President. And therefore my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the President has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament. In this whole situation, the first process is the presidential political process, which ends with the creation of the steering committee. And then there is the process under 257(1), which is the process of the Secretariat led by Junaid Mohammed, and then and a draft process was only undertaken by Dennis Wawero and Junaid Mohammed, and there is no place in which I have found in the record the role of the President. And therefore, on that narrow issue, I have disagreed with the Chief Justice. On the second schedule of the Constitution of Kenya, whether it's unconstitutional, I've said you cannot, as and promoters, purport to amend Article 89(1), leave Article 89(2) to Article 89(12) untouched, and then purport to bring this amendment bill and create new constituencies without involvement of the IEBC creation of new constituencies. Motive question in Kenya, and that is precisely why Section 89 is very elaborate as to the procedure to be undertaken when new constituencies are being created. And therefore, for those reasons, and for the reasons given by the Chief Justice, I've agreed that that schedule is unconstitutional. But I've said something a little more. To create new constituencies, follow the process under 89. Do not ignore IEBC, don't ignore the people, and if you wish to start the process within Section 89, Article 89, you are permitted to do that, but do not go outside the remit and permits of Article 89. The remedy of impeachment of the President should there be a violation of the Constitution. I've also addressed my judgment in the High Court in the Isaac Aluocher case on representation of the President by the Attorney General when the President is sued in his personal name. I have said for violations of the Constitution, and should he be sued for whatever reason, then the proper... I had lawyers for the president agree with them that such an order would have been efficacious. In fact, the nature of this particular litigation being in the public interest, I would not grant the president orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributable to IEBC and to the initiators and promoters. IEBC was... It is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by IEBC and popularization of the bill that had been reached by the time the High Court stopped the process. A last issue raised a fundamental question. Framework to govern processes under Article 257. There is no law on collection of signatures. There is no law pass the amendment bill, the processes by Parliament, despite the standing orders. I have said it is about time to avoid the confusion that I'll address shortly as address issue number 6 and 7, that we need a law. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary. And therefore, the second schedule, in my mind, is an exception, save for the second schedule, where I have said that it's unconstitutional for the reasons that I've given. Articles 88 and 250 with regard to composition and quorum of the IEBC, the Katiba case by Chacha Mwita J. I have Article 1. I have taken into account the very lucid submissions by Esther Angawa regarding Article 88.5, and I have said that IEBC. The second issue raised by Ms. Kituku regarding nullification of the laws, well argued as the point was and lucid as arguments were, I've declined the invitation to address that question because once I've found IEBC correct, other matters are irrelevant. The last issue is issue number 7 on the proposals, whether proposed amendments should be submitted as separate and distinct referendum questions. Like the Chief Justice, I have looked at the law of ripeness and mootness. I have looked at the law on justiciability, and I have come to the firm conclusion, like Justice Tuyot, that this question is its mandate as the body to conduct the referendum, to draft the question or questions, and I have said only this as regards 49 of the Elections Act and Section Article 257 do not sit well together, and I have asked IEBC to, as they reconsider this question, to look at Section 49 of the Act and Article 257, harmonize the language. I have shown why with that issue, and only then would any party with a dispute go to court. Once the IEBC has determined the matter within its mind, we shall walk into a minefield. And therefore, in conclusion, Summary of my findings are as follows. The case has not attained wide acceptability and cannot certainly be applicable to Kenya, noting our history, context, and amendment process are also not applicable, save in the creation of a new constitutional order, which is not the case in this dispute. Number 2.7, it is my finding that he cannot, but I've said also that in this particular dispute, he did not. On the second schedule, without the input of IEBC, without amending Article 89, 1 to 12, without involving affected persons and the public at large, I have held that is indeed unconstitutional. Can civil proceedings be instituted against the president during the term of office? I have said no. And should he be sued, then the proceedings should be against the Attorney General, and any remedy for a suit directly against the president should lie in costs awardable to the president. On public participation, at the time the unconstitutional for inter alia lack of public participation. On the quorum of IEBC at all material times, I find that IEBC was correct and all its undertakings were lawful. On the question whether a referendum, single multiple questions should put the people by IEBC, I find that the matter was premature and was not ripe for determination. On costs, the public interest exhibited in this matter will me to the conclusion that each party should bear its cost. My reasons.
Thank you, Honorable Mr. Justice Naora, for rendering your opinion. I will now call upon Lady Justice.
Thank you very much, Chief Justice. I will proceed to summarize my judgment. On some issues I will be brief. Others I will interrogate them a little bit more. Issue number 1, is the basic structure doctrine applicable in Kenya? In order to determine whether the basic structure doctrine is applicable in Kenya, there is need to define the term doctrine and on the definition of a legal doctrine. But to my mind, the basic structure doctrine as presented by the parties to us is a judge-made law emanating from the municipal court, which is the Supreme Court in India, in the Kesavananda case. That basic structure doctrine has been upheld and relied on in subsequent decisions in India, and I note that there are few jurisdictions does not constitute a widely adhered to a legal doctrine. It is my observation that the basic structure doctrine has been both applied and rejected. I have listed the countries in which that has happened, and therefore it is my considered opinion that the states only constitute a very small percentage of countries in the world that have attempted to apply or have applied the doctrine. Furthermore, there have been no pronouncements made at the international level, no international case law on the same. The only available cases are from domestic courts at national jurisdiction, and therefore it cannot be said that the basic structure doctrine of Kenya 10. The above notwithstanding, is the basic structure doctrine as presented by the parties applicable in Kenya? It is my considered opinion the answer to this question can only be deduced by our constitutional past. Kenyans stressed the fact that they needed a constitution that had entrenched provisions on certain aspects, was not too simple to amend, and one that required their participation in terms of amendment. The final report of the Constitution of Kenya review into our current constitution, where Chapter 16 of the Constitution is unequivocal on how to amend the Constitution. It is therefore my position that it was the intention of the drafters of the Constitution to protect or entrench the specified 10 matters in Article 255(1) by stipulating their specific amendment procedures. If the drafters of the Constitution intended to entrench or protect any other provisions or deemed them eternal or unamendable or constituting eternity clauses, a textual reading of the Constitution confirms this view. It is evident, therefore, that the Constitution itself expressly provides an inbuilt amendment procedure for any anticipated amendments. Consequently, it is unnecessary to import the so-called basic structure doctrine. And I find that the constituent power is a power that cannot be limited by any pre-existing rules, even if such rules purport to regulate replacement of the kind not expressly provided for and cannot be inferred from Article 257 of the Constitution. As such, those steps cannot be a mandatory requirement when there is no. The next issue as to whether the President can initiate changes or amendments to the Constitution. The Court of Appeal upheld the High Court's finding that the President, for as long as he held office, could not, as an ordinary citizen, move constitutional amendments through a popular initiative on the ground that the same route is intended for ordinary citizens. The appellate judges found that the amendment bill was not opposed to the people of Kenya. Some respondents have urged that the proposals by the BBI task force could have been taken up by anyone else, by any promoter, but not the President himself. Having perused carefully through the judgments of the superior courts and also through the Constitution of Kenya, I find this proposition is untenable for several reasons which I shall expound upon. However, before I expound on my views, I must state I'm rather disturbed and concerned by the way the superior courts framed their issues for determination. The High Court framed its issue 3 for determination on them. At paragraph 388 of its judgment, the High Court framed the issue as follows. What is the constitutional remit of amendment of the Constitution through a popular initiative? This issue can initiate a popular initiative under our constitutional setup. And 2, the BBI process is the BBI process of initiating amendments to the Constitution in conformity with the legal and constitutional requirements. And 5, was the President in contravention of Article 73(1) of the Constitution for claiming authority to appeal? Musinga, President of the Court of Appeal, listed the following issue for determination: whether the President of Kenya can initiate, and who the initiators and the promoters of BBI initiative were. The learned judges of appeal unanimously agreed with the High Court that the BBI Constitution was intended for ordinary citizens. Further, they stated that this is a citizen-conceived, citizen-initiated, and citizen-driven process. A lot of time and attention was dedicated to the meaning of certain words. This would not be problematic if these words were found within the body of the Constitution. The Constitutional Court must confine itself to interpretation of the letter of the Constitution, and if any, this is the rule of interpretation at play. The words I'm concerned about include initiate and initiator, citizen-initiated, and private citizen. None of these words appear in Articles 255 to 257 of the Constitution. The High Court in particular went on a spirited approach to expound on these terms and paid little attention to the words that actually appear in Chapter 16 of the Constitution, which are the words promoter, popular, and initiative. In my opinion, the learned judges introduced a non-constitutional initiator. As such, the emphasis was laid on the actor initiator. This, in my opinion, fundamentally changed the import and meaning of Article 257 of the Constitution, and I am of the opinion that the correct approach should have been to define what a popular initiative is and who can be or who is a promoter of a popular initiative. The superior courts ignored the fact that the drafters of the Constitution used certain words and went in to read in words whose effect is to the framers have left out a word or phrase from a provision. Further, this reading in must be supported by other connected provisions of the Constitution. Looking for proper reasons for the decision to exclude the President from the amendment process, and I cannot find a logical, constitutionally based explanation for the conclusions and findings of the superior courts on this question. I can only term it as interpretational misadventure, if not judicial constitutional overreach or judicial invention. As such, the learned judges erred fundamentally on this, and in my considered view, which I shall now expound on, I will specifically look at the Constitutional Amendment, the exercise of the authority of the people under Article 1, the authority of the President under Article 131(1)(3), and the political rights under Article 38. The Constitution 2010 provides for two processes through which it can be initiative. For the popular initiative, promoters, after collecting the signatures of at least 1 million voters, submit the signatures. The bill must then be approved by a majority of the county assemblies, and then approved by a majority of the houses of parliament. It then goes to referendum, where the majority of voters must support it. Article 257 does not define popular initiative. Nevertheless, at the heart of construing the meaning of popular initiative, it lies with the numbers. It is proper to lay emphasis on the numerical value of at least 1 million registered voters who have to sign, the numerical value of at least half of the counties who have to vote to support them. It is the numbers that count. It is the numbers threshold that the promoter must meet. It is the numbers that makes the initiative popular. Of the Constitution, a promoter needs at least 1 million registered voters to support their proposals. That's what triggers the IEBC initiative. Is primarily about numbers that the promoter must attain, and not about who the promoter is or who the person who brings the amendment is. As such, the superior courts made a fundamental error by determining that popular, the word popular, relates to who moves the amendment and not the numerical threshold that the promoter has to attain. So, for example, in 2016, it is important to note also that Section 257 does not in any way specify who may move a constitutional amendment process by popular initiative. It does not contain an explicit bar against any person promoting a constitutional amendment by popular initiative. It specifically provides what actions the promoters are tasked with in order to begin and complete an amendment process, but it does not state who the promoters must be. The answer Sometimes, knowingly or unknowingly, the drafters of the Constitution may underappreciate how much power rests in the silence around the text. Functional